but all of this applies to protecting your IP when you're manufacturing as well. So I always talk about how there are 3 keys to protecting your IP in China. And actually, there are 3 keys to succeeding in China manufacturing. And a lot of times people will say, well, there are a lot more keys than this. You're ignoring things like quality control, etc. Well, I'm focusing on the legal side of things, not the actual manufacturing side. So what are the 3 keys? Structural protection, good contract, and good registration. And I'll talk about each of those in turn. Let's see if I can make this work.
That's the air conditioner remote.
That's what I was thinking. It's a little bit too cold in here, so it's a little warmer here. It also doesn't help that I'm not wearing my glasses.
We don't have a remote for it.
Oh, okay.
Got locked up or something. So
Okay.
we should be able to do it.
All right, so structural protection, it's a word that it's a couple words that a term that I think I've created because I didn't know what else to call it. But basically what it is the things that you can do to protect your IP that do not require a lawyer. And I think it's very important to talk about this sort of stuff because a lot of times our clients hire us and think, oh, well, you know, we've hired you, we've registered our trademarks, we've registered our patents, we're all done here. Well, it's not that simple. And in fact, a lot of times, for a lot of clients, what they do to protect their IP, just in their day-to-day lives, can be more important than something like a trademark or a patent or a good contract, which oftentimes just serves as backup. And an example I always like to give is a lot of times clients come to us and they'll say, you know, can you write, I hate to bring this up again, and hopefully Steve won't talk about it again, but the first time clients usually come to us in a manufacturing context is they'll say, can you write an NDA? And we'll say yes, and we'll say, but it's really an N. And then they'll say, and we charge a flat fee for those. And then they'll say, okay, that's fine, but we need 20 of those. And are you going to charge us the same flat fee for the 20? And the answer is no, because once we get one down, it becomes a lot easier. But the other answer I give is, you're going to send out NDAs, for lack of a better word, to 20 companies. Is that really a good idea? You know, for you to expose your secrets to 20 companies. And they'll say, well, I have this NDA. Well, yes, I mean, that NDA is going to protect you, but it's not foolproof. I mean, come on. It greatly increases your odds, but if you're revealing your secrets to 20 companies, your odds of them slipping out are probably double than if you reveal them to 10. And so what I often do is I'll say, look, if you're going to, let's say, outsource this bottle, and you just need to get the pricing and determine whether someone is capable of making the bottle, you don't need to reveal every element of the bottle in order to get the price. Just tell them, you know, you're making this bottle, and don't tell them that the band is red and that you have a green triangle here, etc. And you could send that out to 20 companies. You don't even need an NDA. And then out of those 20, you're going to rule out 15 of them right away because they're going to be too high, some might not respond, etc., etc. Then when you're down to 5, you have 5 serious candidates, then let's talk about an NDA, and your odds just went up. And then there are all sorts of other things that you can do, like not reveal your secrets to all 100 of your employees. Make sure that your employees don't email your secrets to every vendor, etc., etc. So I always want to stress it's important that you not just abandon your own senses just because you've got a patent or whatever. So one of the most important things, believe it or not, in protecting your IP is choosing a good partner. What I always say is that if you choose a legitimate Chinese company, the odds of you losing your IP have just gone down. A lot of times when people lose their IP, it's because they've lost it to someone they should never have done business with in the first place. And a lot of times when people lose their IP, it's not to some company that they've never dealt with, it's to their vendor, it's to their supplier, it's to their partner, it's to their employee. So do the due diligence. Matthew from InTouch talked about that a bit, and it is really important. And when Matthew was talking, I was reminded of a client that was in my office, and there were 5 of these people, and they probably, between them, had 125 years experience in their industry. And their industry was making a pretty expensive part for the trucking industry. And they had just come back from China after having met with 3 or 4 companies to try to determine who they should use to manufacture this truck part for them. And they told me about these various companies, and I was listening, and I was listening pretty intently. And then after they told me about all of those companies, they turned to me and said, who should we choose? And, you know, as a lawyer, I am trained to give an answer to every question, and as I'm giving the answer, I'm supposed to think of a better answer. And so they asked me that question, and for a second I went blank, because I'm sitting there thinking, they think I'm the China person, they've asked me who to choose, and I have no idea who to choose, because what the hell does a lawyer sitting in Seattle know about who to choose to manufacture this very expensive truck component? But I didn't want to just flip it. I didn't want to say that. But then I realized, wait a second. They know who to choose. And I turned to them and I said, you know who to choose. Who would you choose if these 4 or 5 companies, or 3 or 4 companies, whatever, if they were in Peoria, Illinois? And they were immediately relieved and said, we would choose company number 2. I said, well, choose company number 2. And the point of this story is that there are a couple points of it. One is that you do know what you're doing when it comes to your own product. So don't necessarily rely on others. But the other moral of the story is go out and look. Meaning, don't necessarily rely on other people. Go to the factories and see what's going on there. You, especially people here who are in such a good position to do so. And a lot of times people think that they really don't know manufacturing, don't know what to look for in a factory, but just by going there, even no matter how much of a neophyte you are in manufacturing, you can tell a factory that appears to be well run, that's clean, and a factory that's in complete chaos. And if they appear to be in complete chaos, they probably are, and your products
you know, a story on that, on going to the factory. I took a group to China, and they were in the business of making really nice home furnishing designs that were from glass and ceramic. And this was a period when the stuff was just being copied like crazy in China. And so their main concern was to find a manufacturer that wasn't going to copy their product, right? And of course, all the manufacturers said, oh yeah, we get that. We don't copy products. You know, we would never do that. And we walked into one of the best factories in the part of China we were in. And we walked into the back room, and on their tables were 10 products that they were copying. So, but we would never have found that out if we hadn't gone to the factory. And typical the way those guys are, they didn't try to hide it. They said, yeah, that's our business. I mean, what are you talking about? You know, we copy stuff, and there it is. But you would never find out if you didn't go to the place.
Right, and I mean, that sort of thing, it happens all the time. So, now, so you do your due diligence. This, where I've written here, can be illegal, can be fake. This is more what I call legal due diligence, where you try to figure out, does this company really exist? What has it done, etc. Certain sorts of due diligence in China are illegal that would be perfectly legal in other countries, so you have to be really careful. You also, needless to say, have to be careful about documents being faked, but that's probably a more relevant subject for people in the United States. I'm going to guess that most of you here knew that already. So now let's talk a little bit about IP registrations and what you should be doing to protect your IP through registrations and where it should be registering. There are three main areas of IP that can be registered: patents, trademarks, and copyrights. Patents, there are essentially two different kinds of patents in China. There are utility patents and design patents. I'm going to very grossly summarize the two. Utility patents are what people think of as patents mostly. They can be complicated. It's the mechanics, it's the utility. The patent on this microphone might involve some method or some interior component that is unique and innovative, etc. And if you patent that, then no one else can copy it, or it's legal. Design patents I'm finding those to be very interesting in China, because design patents, no one talked about, well, no one still talks about those, but everyone made fun of design patents until a couple of years ago, because they're commonly called junk patents. And what those are is the design. Let's say the design of this bottle, I could patent that. Now, what makes design patents so interesting in China is that everything in this room I could get a design patent for, even though I had nothing to do with it, even though it's not the least bit unique. What I always tell my clients is I could design patent my socks. And the reason I could design patent my socks is because design patents in China are not reviewed. So if I filled out the form correctly, I could, and if I claim that I invented my socks, I could get a design patent on it. Now, anyone could challenge that design patent and say, that's ridiculous, it's nothing unusual, and you didn't even invent it. And they could get it stricken. So what's the value of a worthless design patent on socks? Well, the value, which Chinese companies have learned, can be tremendous. And so I'm going to tell a story about a company that came to us a few months ago, and they did everything wrong except one small thing, which may end up saving them. And what this company did, this company made widgets, of course, and they went with a factory in, I forget even where, somewhere in China, and we'll call that factory Company A. And Company A was making the widgets for our client, and the widgets were selling like crazy. Unbelievably well, unbelievably profitable. And Company A was not able to keep up with the demand. So our client decided they were going to switch the manufacturing to Company B. So they did so. And within a week or two, Company A writes a letter to Company B and says, you better stop making these widgets because we own the design patent for these widgets and we're going to block them from leaving China at customs. So what we then had to do is sue in China on the design patent. And we did so, and we're waiting for the ruling on that. And fortunately, our client had documentation to show that it was using this design before the company in China registered the design patent. Well, the company in China was not happy about our suing them on the design patent claim, so they started selling our clients widgets for, let's say, $90, whereas our client was selling those same widgets for $125. So they start selling them on Amazon, eBay, etc., and our client ends up having to reduce the price of their widgets in order to compete with their own widgets. And so we then sued the Chinese company for violating our client's trademarks and copyrights. And very briefly, trademarks, trademarks are essentially brand names and logos. Adidas is a trademark. Adidas has trademarked the name Adidas. Nike has trademarked the swoosh. That means only they can use it. Now, the way trademarks work is they are country specific. So if you have a trademark in the United States, it's worthless in China. If you have a trademark in China, it's worthless in the United States. What's interesting about an interesting difference between the two countries is that most countries in the world, including China, are what are called first-to-file countries. So if I were to register the trademark Nike before Nike did it, even though Nike is selling Nike shoes all around the world, well, I would get the trademark. But in the United States, it's a first-to-use country. United States, England, Canada, Australia, the Commonwealth countries, a lot of them, are first-to-use country, which means that Nike, even if they don't register their trademark in the United States, would own it because they were the first to use it for, let's say, shoes. And then copyrights are generally content. Your movie, your music, your your software, and in China it can go a little bit beyond that for some interesting things, like avatars and dolls. You can take pictures of them and you can copyright them, which is a little unusual. But so we sued on trademarks and copyrights, which they had in the United States, because they had a trademark on their name in the United States, and the copyrights, the company A, the Chinese company A, was using our client's photographs. Well, that made them even more unhappy, and so what they did was the Chinese company A flipped around and sued our client in the U.S., claiming that our client was violating their U.S. design patent. Because what they had done, our client had filed for a U.S. design patent, but the Chinese company had used their Chinese design patent. This is a method for getting a rapid filing of another patent. They had taken their Chinese design patent and used it to secure a U.S. design patent. So now we're fighting them in 3 lawsuits. And what should our client have done differently? A lot of things. were on this page, so I'll talk about what they could have done. They could have filed and should have filed their design patent in China. It's not expensive, it's not difficult. They could have done it as a defensive measure. And we never talked about this 2 or 3 years ago. This was not something we talked about with our clients. Now it's something we talk about all the time. Particularly in the IoT and the hardware space, because you can get, another good thing about these design patents is you can get them a lot faster than you can get a patent. So a lot of the bigger companies, what they'll do is they'll file for a design patent right away, and then they'll file for a utility patent, and then once they get their utility patent, they let their design patent lapse. But design patents have now become valuable, and if our client had registered their design patent in China, they would have been pretty much fine. Trademarks. Trademarks are interesting in China because people think, I don't need a trademark in China. I'm not Nike. I'm not selling anything in China. Well, no, you're not. But someone else can register your trademark and stop your products from leaving China. And we see that all the time. We were dealing with, there were 4 companies from all around the world that basically dominate a particular industry. And all 4 of these companies were having their widgets made in China. And someone in China, almost certainly someone related to the factories that were making, one of the factories that were making widgets for these 4 companies, registered in China the trademarks for all 4 of these companies. And so these 4 companies got together and called us up and said, our products are being blocked at customs. We're running out of inventory. What do we do? These companies in China are going to take over the market. And we researched the heck out of this. We talked with all the customs officials, everybody in China, and in the end there was nothing we could do because this Chinese company had beaten our 4 clients to these names. And they could not get their products out of China anymore, which meant they couldn't manufacture in China anymore. And I don't know what they did after that. I don't know if they went back to their respective high-priced countries and tried to manufacture there like they had done probably 5 or 10 years earlier or what. But they basically got shut out from manufacturing in China. And that's very relevant to hardware manufacturers because you could start selling your product and not be able to get it out of China. And a lot of times the timing can be really bad for companies like you all here in this room because you put your product up on Kickstarter and let's say your product is spring widgets and there are people in China who study Kickstarter and they'll go off and they'll register the word spring for widgets, and then maybe 12, 14 months later, they have the trademark, and that's maybe 2 months after your Kickstarter ends and you're about to launch your product, and you can't get it out of China, and that's it. And they start shipping products similar to yours, maybe without your name, because they can do it without your name, and get it into the United States without violating U.S. trademark laws, and you have no problem. So, I mean, it happens.
So Dan, let me make 2 comments on that. The thing about registrations is you have to do it. You know, we talk about it, but you have to do it. And the tendency with young and old companies, particularly young companies, is to say, well, we'll do it later. After we get famous and after we get rich and after we have money, then we'll do it. But that's too late. You have to do it. I mean, you can't just listen to our talk and then say, oh, yeah, okay, I get it. Yeah, I know what a trademark is. You have to actually do it. And this client that Dan's talking about, they're spending hundreds of thousands of dollars?
Well, yeah, I mean, that's the thing. When I stand up here and talk about how you need to register your IP, a lot of you, in fact, how many of you are thinking, well, of course he's going to say that. He's a lawyer, that's how he makes money. How many of you are thinking that? Raise your hand. No, come on, you're all thinking that. Be honest. Yes, exactly. No honest person, okay. But the reality is, we would love nothing more than for you to not register your trademarks. Because registering trademarks is nothing. It's not very expensive. We get one case like this one, and in 1 month, no exaggeration, we can probably make the equivalent, just one case, one company, 1 month, we probably make as much as all our other clients with their IP registrations.
That do it right.
They do it right for an entire year.
So this and it is cheap too. I mean,
yeah.
This morning I was in a trademark registration meeting, right, specifically for my company. We're registering across 6 categories. It's costing us 7,000 renminbi just to register the trademark.
Right. It's not a big.
So if this company had just done it, right, and it would have been, this company didn't even have an excuse. They had a lot of money. It's just that they were dealing with people who never told them to do it. It never occurred. So one is to do it. The other is, that I just wanted to point out there, is Dan mentioned the people that look at your Kickstarter campaign and take. But in our experience, the people who do it to you is your friends.
Your manufacturer.
Okay? It's your friends. It's not strangers. It's your buddies. And what happened there with this case is you're working with a factory. We get this all the time. You work with a factory and they're not adequate for some reason. They either can't do the capacity, or they're raise the price too high, or the quality's no good. And so you make the terrible mistake of threatening that you're going to go someplace else. And this happens all the time. They get the word you're going to go someplace else. They know you really well. They know you haven't registered your trademarks. They know you haven't gotten a design patent. So as soon as they hear that you're going to dump them, they race off and they register all your trademarks. And they register, and this, now that they're smarter, they register a design patent. See, this company that did this, they didn't originally register the design patent. They only did it when they were threatened with being cut off.
When they were cut off.
Right? And the other thing that happens is you're really good buddies with the owner of the factory. Right? And it's true, you're good buddies. And you say, my buddy, Mr. Joe, would never do that. That's correct. Who does it? The assistant manager. Okay? It's true. Mr. Joe would never do it. So the first client that I ever had that was bankrupted by intellectual property theft, I went to the client and I said, don't reveal your software to your distributor. Don't reveal it. And they said, oh, Mr. Joe would never steal our software. It will never happen. Right? And it was oil exploration software. And I went to Japan, I worked in Japan 2 years, came back, and this company was bankrupt. And I said, well, why are they bankrupt? The assistant manager took the software and went to Iraq, where oil exploration is done, and bankrupted the company. So, and the point of all that, if this company had done what I said, they wouldn't have gotten bankrupt. But you have to do it, and then you have to understand that the people that are going to do it to you are the people that you already gave everything away to, right? And sure, they're your friend until you tell them you're going to fire them. Then they're not your friend anymore, right? And these guys, 20 years ago, they didn't know what to do. But everybody in China knows what to do now. It's gone viral. right? Everybody knows, oh, you're going to get fired? Here's what you do, right? It's become generally known.
And it's become so prevalent in China that years ago, China said that your agent in China cannot register your trademarks. So your factory cannot register your trademarks in China. But that doesn't matter. Everybody in China knows that. So if your factory's in Shanghai, they're not going to register your trademark. They'll just have their cousin in Xi'an register it, and there's nothing you can do. So that's how it goes down. So there are also 3 key contracts that you should at least be thinking about with manufacturing. There's the MMN agreement, we've talked about that. There's the product development agreement, which is where probably a lot of you have been or are in this stage. That's where you're working with the factory to develop the product. And 10 or 15 years ago, a lot of our manufacturing contracts were really simple. Make these socks, make these rubber duckies. Not very complex. We didn't do very many product development agreements. I mean, the socks, everybody knows how to make socks, not a big deal. Nowadays, with technology products, with IoT products, there can be months of development, there can be years of development. And we've been hit with 2 cases, one involving foam technology and one involving LED lighting technology, where 2 different companies came to us after working with big Chinese companies for about 2 years. They came to us and said, we need a manufacturing agreement. And we asked them, what's been going on? And they said, well, we've worked with this giant Chinese company for 2 years, and they've been great. We've had some bumps in the road, but now we've got our product ready to go. And they've done all this for free. And yeah, somebody's you're shaking your head no. You should be shaking your head no. Because in both instances, we were unable to, we basically said, look, you need to figure out what's going on here. We can't just write a manufacturing agreement because we think you've misunderstood the situation. We don't think that they're going to just say, yeah, we'll now make the widgets for you at $5 a pop, and those widgets belong to you, and if you don't like them at $5 a pop, you can go to the factory down the street. They didn't work on this product development for 2 years to let you go down the street. And in both cases, these big Chinese companies came back and basically said, are you crazy? No, that's not the deal. Here's the deal. We're going to let you sell our product in the United States only for the next 6 months or so. And if you don't do a good job, we'll have someone else sell our product. And these 2 companies said, well, we need to sue them, and what can we do, and all that. And the answer is, there's nothing you can do. You just spent 2 years developing a product for some other company. And they're like, well, but it was our idea. So what? That's not the law. It's not the law in China. It's not the law in the United States. We have nowhere to sue them, unless you just want to pay us a ton of money for a losing case. So I don't know what you can do. So don't let that happen to you. And then there's the manufacturing agreement, where everything can go in that. Quality, delivery dates, pricing matters, et cetera, et cetera. That's usually the key document. Also, you can put in there confidentiality, non-compete, that they can't make your product for someone else, they can't sell to your customers, et cetera.
But for IP protection, though, where we're finding now the danger zone in IP, just specifically that issue IP, is that space between N and manufacturing. Because what people will do is we'll say, okay, you're manufacturing, right? Who owns the design of the product that you're manufacturing? Now, in the old days, it was 100% clear that the foreign company owned the design. You know, they had it designed, and maybe they've been making it themselves for 20 years. But now what we find, what Dan is talking about, is they go to the factory and they say, okay, let's do the manufacturing, and I put in my standard clause. We own the design, you can't mess with it. And the factory comes back and says, I think you made a mistake. You don't own the design. But that's the space where it's been lost, is that in between sort of never land between the N agreement and the contract manufacturing agreement. And this has only been going on, what, 3 years maybe for us?
Yeah.
It's a recent thing.
Yeah, it's a recent thing.
It's about 3 years that we've seen
As
this.
products are getting more complicated, as Chinese companies are getting a lot more sophisticated. So, we're often asked, why bother with a contract? We're usually asked that by Americans, because Americans think of the reason for a contract is to be able to enforce it in a court. And they'll say, can you really enforce a contract in China? And I'll talk about, we talked a little bit about where your contract dispute should be handled. I'll talk about that again in a minute. But the answer, well, yes, you can enforce a contract in China. Can you enforce it 100% of the time when you're supposed to be able to? No, I don't know what the percent is, but it's a lot more than zero, and it's not 100% in the United States either. But there are two other reasons that often are not thought about, and one is clarity. If you're communicating with your manufacturer in English, let's say, there's going to be a lot of cross-cultural leakage, and there'll be a lot of mistaken interpretations, etc. And putting something in writing in Chinese can be a great way to make things clear. And an example I always give, because it must happen 90% of the time. An American company will say, okay, I'm making this incredibly earth-shattering, incredibly complicated product, and my supplier in China says they'll get it to my office in Omaha, Nebraska, 20 days after they get the purchase order. And I'll be sitting there thinking, wow. So we'll put in the contract, the widgets will be delivered 20 days after the purchase order is received. And every day you're late, you have to pay 1% or 2%, it really varies with the nature of the product, 1% of the purchase price. And it goes to the Chinese company, and they're like, oh, I can't sign that. And our client will say, well, you said you could do it in 20 days. No, I can't do that. And so we clarify with them, and it's 45 days. Well, at least our client now knows they're not going to promise, yeah, Mr. Production manufacturing is nodding his head. The advantage is at least you're not promising your downstream customers that you're going to get it to them in 25 days. You're telling them it's going to be 50 days, and so you're not crushing expectations.
And let me, another example on clarity, and Dan's exactly right, is that, give you another example that comes up a lot in an older kind of business I used to do, where what do you do when defective product is identified? What do you do, right? And the danger is that you identify the defective product and the factory sets it aside and then resells it in a different market with your trademark right on there, right? So my standard thing is to say, you destroy the defective product, you destroy it, okay? But I did it one recently with very expensive cast turbine blades, very, very expensive. And the Chinese factory said, well, we're not going to destroy it. There's $10,000 worth of metal in that blade. We're going to melt it down and reuse the metal. So we want you to say that we can recycle it as long as it's just turned into an ingot of metal. Well, that was fine. That wasn't a problem. But if we hadn't talked about it, clarity, we wouldn't have resolved the problem. And it had to be, because the Americans think, well, of course they're going to do this, A, and the Chinese are thinking, it's this cultural thing. The Chinese are thinking, of course we're going to do this, and the Americans thinking, of course they're going to do that.
Right.
And they're totally, and only when we wrote it down did they have a perfectly fine discussion of what they actually were going to do. Where if we hadn't written it down, the American would have come in a year later, saw what they were doing, and said, these guys are a bunch of crooks, this is horrible. And we prevented that whole problem just by writing it down. And it wasn't to have an enforceable contract, it was to make sure they knew what they were going to do.
Right.
And it was very successful.
Bringing the parties together. The other thing a contract can do, and I actually think this is the most important of all, the goal of a contract, the primary goal, even in the United States, isn't to be able to sue and win, especially in the United States where litigation is so unbelievably expensive. That matter I was telling you about, where our client had all these problems, we're staffing that with 5 lawyers who are working all the time. And we've got a trademark litigator, we've got a patent litigator, we've got 2 associates. I mean, litigation is expensive. We just wrote a 28-page brief. I mean, it's really expensive. So the goal is to prevent litigation, and the way you prevent litigation is you prevent the Chinese company from breaching the contract. And the way you prevent the Chinese company from breaching the contract is you have incentives so that they don't want to breach the contract. And I will talk about what that incentive, or actually maybe it's more like a disincentive. I'll talk about what that should be in a minute. So now I'm going to briefly review what makes a good contract. Because having a contract that's terrible is not going to help you. So in dealing with a Chinese company, now I'm going to assume we're talking about Chinese law in a Chinese court. The contract should be in writing, not emails. It should be an old school contract, preferably chopped by the Chinese, sealed by the Chinese company. It should be one language. There are a lot of lawyers who like to write dual language contracts. We write dual language contracts, meaning they're, let's say, Chinese and English, but we're always clear which language is the official language. And the reason that's so important is because if you have 2 languages, you are just doubling the likelihood of ambiguities, because you're doubling the number of words. You might have a word in English, a word in Chinese, and you can argue what the word in English means, you can argue what the word in Chinese means, you can argue what they sort of were meant to mean together. So you're taking all this time, you're adding all this ambiguity. I was giving a talk at the American Bar Association many years ago, and I said, I don't know why any lawyers draft double language contracts. And somebody raised his hand in the back, a lawyer, and he goes, I know why. And I go, really, why? And he goes, because we make so much more money that way. And I thought, yeah, he's right. Because when we're called on to handle, let's say, an arbitration or a litigation with a dual language contract, we almost immediately need to double staff that case, because we can't just have a lawyer who speaks English on the case, and we can't just have a lawyer who speaks Chinese on the case. We need both. Right there, the cost just went way, way up. So but that's the only good reason I can think of for doing that. The other thing you need is you need your contract to be written in excruciating detail. The story I always like to tell is an executive in Shanghai. This is not, I don't think this is a true story, but I heard it a long time ago, and I've been telling it myself ever since. An executive in Shanghai was renting an apartment, and he had a really nice desk chair, and it was broken. It was a furnished apartment, and he kept asking the landlord to fix it, and the landlord wouldn't fix it. And finally, the lease came up for renewal, and the executive wrote, told the landlord, I'm not going to renew this lease unless you give me a new chair. And the landlord said, okay. The guy wrote out, I'm going to get a new chair. And so he signed the lease, and a few days later, the landlord comes in, or the landlord's messenger, or whatever, delivery person, comes in, and he brings in not, the $600 really nice office chair, but he brings in a $6 folding chair. And the executive thought, that was my mistake, I should have written it in more detail. And he should have. And Americans and Canadians and Brits are particularly susceptible to this because in the United States, if that executive sued the landlord, the executive would win 99 times out of 100 because the U.S. judge would say, well, of course it was clear under the circumstances that he was talking about a really nice $600 chair. You can't do that. But in China, you can do that. And we see things in contracts where our clients will have written, you will make this product at reasonable quality. And in the U.S., that has meaning. That means, it's got to be decent quality, maybe about the average. In China, what does reasonable quality mean? It doesn't really mean anything. One of the first manufacturing matters I had was a long time ago. It was for a laptop bag company that had spent millions of dollars buying laptop bags, and the handles were breaking when you put your laptop in the bag. So we talked with the Chinese factory and we said, look, these laptop bags are no good. The handles keep breaking when the customers put their laptop bags in. We need to do something about it. And the factory said, why? What do you expect us to do? If your client wanted laptop bags that were good enough to not have the handles break, we should have bought our $6 bag, not our $4 bag. And they were right. So if you want a laptop bag that's not going to break, you need to put in the contract XYZ, tensile strength, etc., etc. You have to be specific. Okay, another question we get a lot is, well, why bother with a contract when there's so much corruption? And the story I like to tell to illustrate why that's not a good question is, and I especially like to tell this story when I'm in China because it's maybe a little bit safer, is many years ago, our firm had a case in Russia. I believe it was in Khabarovsk, Russia. And under the contract, a really well-written contract, should have been a slam dunk winner for our client. The Russian company should have to pay our client $2 million. So we brought in this lawyer, and in Russia, a really good lawyer, and we talked to him, and he said, okay, in Khabarovsk, there are 15 judges. 9 of them are corrupt. We're like, okay. Now, one of the things I learned is that even in Russia, even the corrupt judges are honest. If you pay a judge, let's say $50,000 to throw your case, and then he or she realizes that it's just too risky to do so, they'll return your $50,000. So you don't have to worry about that. But so our client, an American company, is a little worried. 9 out of 15, the odds aren't good, and we end up getting 1 of the 9. And so the lawyer says, look, we've got a corrupt judge, and our client's like, well, let's just drop the case. And the Russian lawyer says, no, why would we do that? And our client goes, well, because they're going to pay the judge and we're going to lose. And he goes, yeah, so what? And then what he did is he explained that it's going to cost them, this is a slam dunk case. This judge, they're going to have to pay the judge a lot of money to embarrass himself in front of the Court of Appeals. So that's going to be, my guess is this is going to cost them $300,000, $350,000. And then when it goes in front of the Court of Appeals in Vladivostok, it's going to be in front of 3 judges. And it's going to be riskier to bribe them because it's not even the same town. And what if less than 2 out of 3 are corrupt? That's a risk. And if 2 out of 3 are corrupt, they're still going to have to pay a lot of money. A lot of money. So now, let's say figure they're going to have to pay $800,000. Now we're up to $1.1 million. and they're going to be taking some risk. So they'd rather settle with you for $1 million than have to go through all this. And we ended up settling the case for $1.2 million. Now, in the United States, we probably would have settled it for 1.8 or 1.9. So corruption does matter, but they got $1.2 million because they had a good contract. If it had been a lousy contract, these people would have paid the judge $15,000 and we would have lost on the appeal. Because if it had been a 50-50 case, the Court of Appeals wouldn't overrule it. So, I mean, it really does matter. And the reason I talk about this is because Americans, Brits, we think our system, our legal systems are so pristine that we don't have to worry about these things. And when we do worry about them, we think it's sort of an on-off, yes-no situation, but it's not. Corruption.
But I have a little problem in that I'm a China person. You know, I like China. And so I get a little concerned about this corruption thing. I want to make a comment. The Chinese court system is not corrupt in commercial matters. It's corrupt in criminal matters, and it's corrupt in human rights matters. But the Chinese court system is not corrupt in commercial matters. And every case, personally, that I've been on, where somebody comes to me and says, oh, the Chinese court system is really bad. You can't enforce a contract in China. You can't enforce a contract in China. Every time I've been in that situation, it's because of a defect in the contract. Not the system. It's a defect in the contract itself. Usually it's providing where the contract says you have to litigate in Iowa when it's a Chinese case. But now I've had situations in China where the judges were no good. You know, they were lazy and they didn't spend any time on the case. But they weren't corrupt. They just were no good. And it's the same thing. When you start to sue, even when it's not corrupt, but it's political. It's not corruption thing, it's political. When you're in their hometown doing a lawsuit that's a slam dunk and going to the newspaper every day, you can get tremendous pressure on people. But if you're doing it in Stockholm, you don't apply any pressure at all. There's no pressure. So in China, it's less, with the commercial court system, it's less a problem of corruption than it is indifference and incompetence, which is still difficult. But as Dan said, you still can get tremendous benefit just by being here, in their face, messing with them. But if you write in your contract that you're not allowed to be here, well, then it's over, right?
Steve mentioned Stockholm reminded me of something where Steve talked about how someone changed one little item in a contract and ruined it. Many years ago, I had a client, actually, interestingly enough, the very same client that had the case in Vladivostok. We had drafted a contract for them that said something like the arbitration will be before the Chamber of Commerce in Stockholm or Moscow, I can't remember which. And they took the same contract and used it with someone else, but they changed the provision to, the only change they made that mattered was they changed the arbitration location from Stockholm or Moscow to Geneva. And
wonderful idea.
Wonderful idea, except the problem was that the Chamber of Commerce in Geneva did not do arbitration. And so you had an arbitration clause that really probably didn't necessarily work. So what we ended up doing is we sued there was one major arbitration body in Geneva, and we brought the arbitration there. And the Russian company on the other side said, no, you can't do that because arbitration has to be consensual, and we never agreed to this particular arbitration body. And we argued that that this is what the parties meant. And we figured we would win because these arbitration bodies charge huge amounts of money and they want the case.
Yeah, they want the case, yeah.
Exactly. Right. And we ended up winning. but it ended up costing our client about $80,000 in legal fees, and they had to pay for 3 arbitrators to figure all of this out.
How much did those guys cost? The
They-
arbitrators?
Probably 600, 700 an hour, and that was years ago.
Yeah.
I mean, so it cost them $80,000 to bring the lawsuit only because they changed one word. So yeah, that can be dangerous. So what's a good contract when you're dealing with a Chinese manufacturer? Well, we've talked a lot about this already, but
Dan? It's 9:10.
okay, I'll wrap it up in about 2 minutes. So think about where you're going to have the litigation. You don't want it in the United States because they won't enforce, China will not enforce the judgment. And the whole point of these contracts is to prevent your Chinese party from breaching, so you want to be able to have something hanging over their heads that they're worried about if they breach. And they're most worried about you suing them in China, and if you have a provision that provides for specific damages, that's what they don't like, because you can take that provision and you can go to a court in China and shockingly quickly freeze their bank account up to the amount of the contract damages provision in your contract. And that wraps it up.
And see, now you know where to find Dan. That's good.